5 seconds to go. Start. The alleged act of registration of case crime number 967 of 2007 at the Murad police station Gwalior, and there is nothing to indicate that the respondent number 1 is related to the accused Ashok Dikshit. The council submitted that the charge sheet should be read as a whole, and there exists no circumstance or evidence to warrant any assumption of involvement of respondent number 1 in connection with case crime number 617 of 2007 for the alleged offense of conspiracy to commit murder. This is so because there are only two statements of witnesses recorded under section 161 CRPC, and such statements were recorded after a period of 1 year, that is on 25th October 2008, from the date of registration of case crime number 617 of 2007, that is on 12th October 2007. These two statements are the sole basis for instituting a prosecution against the respondent number 1. Furthermore, the said witnesses were not examined in the trial, whereby the 12 accused, including Ashok Dikshit, stood convicted while order dated 10th July 2015. It was also submitted that there is a material contradiction in the case of the prosecution. The statements of the two witnesses, that is Ramesh and Bade Lal, suggest that the respondent number 1 was seen with Ashok Dikshit in Gwalior, since they had verbatim deposed that they had heard respondent number 1 telling Ashok Dikshit that they would create a false plea of alibi. However, the eyewitnesses have all deposed that Ashok Dikshit was present at the place of the incident in Firozabad where the firing had occurred. These two contradictory statements confirm the presence of Ashok Dikshit in Firozabad and also in Gwalior, and are therefore ex facie derogatory to each other. The council submitted that section 201 CRPC would not apply to the instant facts and circumstances. There is no allegation that the respondent number 1 had conspired with the other co-accused persons for the offense of murder, and the only allegation that surfaces from the charge sheet is that a false alibi was provided in order to shield Ashok Dikshit by registering an FIR under the Excise Act in Gwalior. The said alleged act was made after the commission of the offense of murder, and there is nothing on record to even remotely suggest that the respondent number 1 had knowledge about the incident of murder. In light of the above, the council submitted that the impugned judgment and order of the High Court quashing the criminal proceedings against the respondent number 1 may not be interfered with. Miss Nanita Sharma, the learned counsel appearing for the respondent numbers 3, 4 and 5 respectively, submitted that the Uttar Pradesh police was bent upon falsely implicating her clients for the offence under sections 302 and 120B IPC. This is evident from the following. The statements of Ramesh Yadav and Bade Lal were recorded under section 161 CRPC after a gap of 1 year from the date of the offence committed at Firozabad, that is 12th October 2007. The address of Bade Lal as recorded by the IO while recording his statement under section 161 CRPC was found to be incorrect, and as per the information of the Sarpanch, no person with the name of Bade Lal had ever lived at the said address. The permanent address of the witness Bade Lal was not in existence even as per the certificate given by the Parshad of the area on 28 December 2008. Ramesh Yadav had also never lived at the address which was given by him to the IO during his statement recorded under section 161 CRPC, and the same was clear from the certificate issued by the Sarpanch of Bada Gaon Murad Police Station, Gwalior. The council also submitted that the respondent numbers 3, 4 and 5 respectively had never been named in the FIR registered in case crime number 617 of 2007, nor their names were ever disclosed by any of the witnesses whose statements had been recorded by the IO under section 161 CRPC after the commission of the offence at Firozabad. It was never pointed out that there was any conspiracy between the respondents and the main accused Ashok Dikshit. It was submitted that the respondent numbers 3, 4 and 5 respectively or their family members are neither relatives nor known to the accused Ashok Dikshit in any manner. The council submitted that the IO at Firozabad has falsely implicated the respondent numbers 3, 4 and 5 respectively in the murder case which occurred at Firozabad even though they had no role to play in the case. They have been implicated only because of the rivalry between the two police establishments and the refusal of the DIG Gwalior to grant sanction to prosecute them. It was submitted that the respondents had only performed their duty without suspecting any kind of manipulation in both the arrest and release of Ashok Dikshit because they were merely following the instructions of their superior officer, that is, the TI SHO DS Kushwaha of the Murad police station. The council in the last submitted that the High Court was justified in quashing the criminal proceedings against the respondent numbers 3, 4 and 5 for want of sanction. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only issue that falls for our consideration is whether the CJM Firozabad could have taken cognizance of the charge sheet number 3A of 2008 and charge sheet number 30 of 2009 respectively against the respondent numbers 1, 3, 4 and 5 respectively in the absence of the grant of sanction for prosecution under section 197 CRPC. In other words, whether the offence or the act alleged to have been committed by the respondent numbers 1, 3, 4 and 5 respectively could be said to have been done while acting or purporting to act in the discharge of official duty. Section 197 CRPC reads as under: when any person who is or was a judge or magistrate or a public servant not removable from his office save by or with the sanction of the government is accused of any offence alleged to have been committed by him while acting or purporting to act in the discharge of his official duty, no court shall take cognizance of such offence except with the previous sanction, save as otherwise provided in the Lokpal and Lokayuktas Act 2013. In the case of a person who is employed or, as the case may be, was at the time of commission of the alleged offence employed in connection with the affairs of the Union of the central government. In the case of a person who is employed or, as the case may be, was at the time of commission of the alleged offence employed in connection with the affairs of a state of the state government. Stop.